Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. You're listening to episode number 684, and I'm Natalia Angelini.
And I'm Diana McBey.
So hi, Diana. It's nice to be podcasting with you today.
Hey, Natalia.
We are going to be talking about a case that's come out of the British Columbia jurisdiction, and it is called Bautista and Gutkowski. And it's an interesting case. It's essentially what we would liken to here as a dependent support case. And Diana, you can maybe get us kicked off with the facts.
Yeah. This is a case where the testator, Bautista, she in 1974 gave birth to a son in the Philippines. When the son is 3 months old, she moves to Canada to work as a nanny and has to leave her son behind with her parents who raised him. So throughout his life, she's providing financial assistance for her son's living expenses, and she pays for his education up until the second year of university, when she comes through some financial hardship and can no longer help. During this time, he's also got a part-time job throughout high school, so he's contributing himself, but she's certainly helping out with that. When she's able to come back, she does. The first time after leaving for Canada that she can come back is when her son is 7. And then every 3 to 4 years after that, she returns to the Philippines, and he comes to visit as well when he can. During this time, they create a pretty good bond. The son says that they had a very loving relationship and were working on that. And he'd pick her up when she came to the Philippines, and, he really loved his mother. When she dies, however, she leaves this will, which gives 3/4 of her estate to her sister and her niece, and 25% of her estate to her son. So when that comes out, her son brings a case in the Supreme Court of British Columbia to vary the will, to change the percentages that are allotted to him and allotted to his cousin and his aunt.
Yeah, and it's interesting because, it's a bit of a sad situation, right? Because we've got a mother and son. He's her only child. And over the years, she didn't really spend much time with him. She didn't really raise him. He was raised by the grandparents. She saw him once every few years. And though there was, I guess, some financial support throughout his life, maybe the emotional bond was weaker, let's say. And then into his adult years, it looked like it suffered. And he also says, look, it suffered because of my relatives, because my sister, my aunt and cousin didn't nurture that bond, and actually, I think, took steps or disapproved of him, right? Disapproved of some of the things that he did. So that hurt their bond, and ultimately, we see that this is reflected in her testamentary plan. And it was interesting to me because, the court, being British Columbia, the court, that's where the decision, the Tatarin decision had come out of, which spoke to the moral obligation being something that the court can consider, not just the financial obligation. And we've got it applied in this case because we've got an adult child who's essentially seeking support. And we know here in Ontario, it's not as easy for an adult child to advance this kind of claim. But what was unique here is that, this is not a son who was thriving and really independent financially. He was struggling. And, the court looks and the court considered this dynamic, right? Where he was seen as, I guess, a credible affiant or party. And so his version of events was believed, and the mum was sort of viewed with this lens of having abandoned him and, already recognized a moral obligation by giving him 25%, but it wasn't enough. It had to be greater. And so the court decided to give him, to increase that percentage to 60%.
Yeah. What I thought was really interesting is the way the court talks about the British Columbia Wills, Estates and Succession Act, which is a little bit more liberal than our own Succession Law Reform Act, although the two provisions in question are very similarly worded. But, things like where the court is given the power under the British Columbia Wills, Estates, and Succession Act to give provision for maintenance and support rather than just support.
Right.
And, make sure that the amount given to a dependent is adequate, just, and equitable rather than just adequate, which is our own wording.
Yeah. And I mean, that BC statute, it's even stated in the decision, the objective is to weigh testamentary freedom with the obligation to support. And the court also looks at the parent from the view of a judicious parent. So they have that moral duty, but it can also be negated should there be cause, right? Should there be some rational reasons to disinherit the child? And I guess that was not seen to be the case here.
Yeah.
Well, it's an interesting case. I don't know if it would have been decided exactly the same way in Ontario, but certainly one that was worth noting.
Yeah.
Yeah. And so do you have any other thoughts on it, Diana?
I just thought it was interesting, the court's perception of the case, especially considering that the son, wasn't aware that the mother had died, and the relationship with his aunt and his cousin. It was really interesting watching the court go through the dynamics and actually apply morals to the situation as well as the law, which is
right. And that was particularly sad, right? Because he didn't even know until after she had passed, and he had made overtures to have communication with her, and those were met with silence. It was just so troublesome. I mean, just really sad. Oh gosh, I had a thought and it escaped me. In any event, unless you have any other comments, I think that brings us to the end of our podcast, and the case will be on our website. And until next time, you've been listening to Hull and Hull, the Hull on Estates, rather. And I'm Natalia Angelini.
And I'm Diana McBey.
Thank you.
Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.